our Constitution, our state Constitution, inscribes the right to keep and bear arms and designates it unalienable in our state Constitution. It subjects any restriction on that right under our state Constitution to strict scrutiny. So we're very, very serious about it, and the state has repeatedly signaled, and we're talking now about voters who've adopted this. This isn't just the state legislature. These are our voters who have put this into our state Constitution. We've repeatedly said we don't want the federal government encroaching on our right to keep and bear arms in the state of Missouri. The last administration, however, did this repeatedly. Back in 2022, the Biden DOJ actually asked local sheriffs across Missouri for records of concealed carry permit holders, which state law explicitly forbids the sheriffs to turn over. So you can imagine the conflict there. I mean, here you've got DOJ saying, give us your records. And they're saying, well, the state law forbids it, criminalizes it. You're asking me to turn over something that's illegal under state law. And the bigger question is, why do you need records, lists of concealed permit holders in the state of Missouri? Why would the federal government need to have this? They asked for it from multiple counties. They also, as you know, pursued the zero tolerance revocation policy, the expanded framer-receiver rule, all things that Missouri and Missourians have viewed as massive overreach onto our Second Amendment rights. Here's my question for you. Can you commit that under your leadership, ATF will go in a different direction than the last administration, that you'll focus your law enforcement resources on criminals, as opposed to law-abiding citizens who have rights under both the federal and state constitutions? What's your answer?
What happens when a state draws a hard constitutional line and the federal government tries to cross it? Today's hearing wasn't just about nominees. It was about power, limits, and who actually gets to decide. Missouri made it crystal clear. The Second Amendment isn't a suggestion. It's an unalienable right written directly into its constitution. And when the federal government asked for concealed carry records it had no legal right to touch, the clash was inevitable. But that was only the beginning. From ATF enforcement priorities to a rare moment of total agreement on nationwide injunctions, this hearing pulled back the curtain on how much authority federal agencies and judges really have, and where that authority stops. Stay with us, because what you're about to hear explains why this fight matters, who it affects, and what could change next.
Thank you very much. Thank you to all of the nominees for being here. Congratulations to each of you. It's great to see you. Mr. Cicada, let me just start with you if I could. Let's start with the Second Amendment. Missouri, I think that we've got to be the strongest protector of the Second Amendment anywhere in the country. We're a constitutional carry state. We have no state-level permit requirements for concealed carry. Our Constitution, our state Constitution, inscribes the right to keep and bear arms and designates it unalienable in our state Constitution. It subjects any restriction on that right under our state Constitution to strict scrutiny. So we're very, very serious about it, and the state has repeatedly signaled, and we're talking now about voters who've adopted this. This isn't just the state legislature. These are our voters who have put this into our state Constitution. We've repeatedly said we don't want the federal government encroaching on our right to keep and bear arms in the state of Missouri. The last administration, however, did this repeatedly. Back in 2022, the Biden DOJ actually asked local sheriffs across Missouri for records of concealed carry permit holders, which state law explicitly forbids the sheriffs to turn over. So you can imagine the conflict there. I mean, here you've got DOJ saying, give us your records. And they're saying, well, the state law forbids it, criminalizes it. You're asking me to turn over something that's illegal under state law. And the bigger question is, why do you need records, lists of concealed permit holders in the state of Missouri? Why would the federal government need to have this? They asked for it from multiple counties. They also, as you know, pursued the zero tolerance revocation policy, the expanded framer-receiver rule, all things that Missouri and Missourians have viewed as massive overreach onto our Second Amendment rights. Here's my question for you. Can you commit that under your leadership, ATF will go in a different direction than the last administration, that you'll focus your law enforcement resources on criminals, as opposed to law-abiding citizens who have rights under both the federal and state constitutions? What's your answer?
Good morning, Senator. Thank you for your question. I can assure you with absolute certainty that ATF, first of all, under my watch as the deputy director since April of last year, has 1,000% been focused on holding people accountable who have committed violent crimes. We're not here trying to burden unnecessarily the American citizen who has the complete right to exercise their Second Amendment right. to bear arms, and we will not be doing that in the future if I am so confirmed.
You've got 20 years of experience over that, I think, at the ATF, and then a lot of experience in anti-gang enforcement with NYPD. Just give us a sense of how you'll bring that experience to bear to ensure that the operational resources, should you be confirmed, the operational resources of the agency will be prioritized towards dismantling violent criminal networks, illegal firearm trafficking networks, and the like. How are you going to ensure that this is the priority, not querying the lists of permit holders in my state, for example?
Yes, sir. So first off, unlike some prior ATF directors, I will still be a sworn law enforcement officer if I am confirmed. I've done this job from the ground level police officer, learning to be an investigator, a task force officer with ATF. I have 34 years of experience of not telling people to go out and make cases. I made the cases myself. So I know what it takes. I know that we can't do it alone because we're a small agency. I've worked with practically every ATF agent that's actually out here making cases. We all know each other. And here at ATF, we respect federal law enforcement officers that do the job, not talk about doing the job. Those of us that have done the job, we know to stay focused on violent criminals, and that's what you pay us for, and we will continue to do that.
Terrific. Terrific. Thank you. I look forward to working with you. Let's talk a little bit about nationwide injunctions here with the judicial nominees. By the way, congratulations to all the judicial nominees. This is going very well for you because there's nobody in the room on the dais. So that's when you know, like, you're doing great. You're doing great. Let's just talk a little bit about what you understand the scope of your equitable power to be when it comes to granting injunctive relief to non-parties who are in front of you. This is something that we've seen happen repeatedly over the years. We've seen Republican-appointed judges do it. We've seen Democrat-appointed judges do it. Give me your understanding of what it is, what kind of equitable injunctive relief you can grant to a non-party should you be confirmed. Let's just go down the dais, and we'll start with you, Mr. Davis.
Thank you, Senator. The governing case on this is the Supreme Court's recent case in CASA, which made clear that district court's power is limited to providing full relief to the parties before it. So there's no ability to simply provide relief to parties that are not before the court simply because that is the policy view of the judge or something. It needs to be limited to the parties and full relief.
Good. Very good. Ms. St. John.
I concur with Mr. Davis's response.
Okay. Mr. Shepard.
Senator, I concur with my colleagues.
Mr. Wolf.
Senator, under Trump v. CASA, district judges lack authority to provide for relief for parties not before them when they're using equitable power.
Good. Okay. So I'm glad we're clear on it. It sounds like everybody agrees that you cannot bind. As a district court judge, it would be your understanding that you're not able to use your equitable powers, which injunctive relief, of course, is inherently equitable. You're not able to use those powers to bind non-parties who are before you. Is that, we all agree on that? Yes, Mr. Davis?
Yes, Senator.
Ms.
Yes,
St. John?
Senator.
Yes, Mr. Shepard?
Yes, Senator.
And Mr. Wolf?
Yes, Senator.
Okay, I've got some other questions that I will give for you, give to you for the record. I just want to say in closing, with regard to you in particular, Mr. Davis, and I'm sorry that Senator Cruz is not here. You served with Senator Cruz for a number of years, and it's a little bit like that episode of The Simpsons, I think, where Lisa's in a science project, and it's like a great project, and the judges look at it and like, yeah, very impressive, and then they go and meet Homer, and they come back to Lisa and they say, having met your father, we're awarding you bonus points. Having served with your former boss, I'm awarding you bonus points. Mr. Davis, you're going to be tremendous. You're all going to be tremendous. Congratulations.
The hearing quickly moved from congratulations to confrontation. Missouri's position was unmistakable. Its voters, not Washington, have repeatedly affirmed the right to keep and bear arms, elevating it to the highest level of constitutional protection under strict scrutiny. That made the Biden administration's actions especially controversial, particularly the DOJ's 2022 request for concealed carry permit records. State law explicitly forbids local officials from sharing. At the center of that tension was the ATF. Pressed directly on whether the agency would continue policies viewed as federal overreach, the nominee drew a clear line. He emphasized that under his leadership, ATF's focus would remain squarely on violent criminals, gangs, and illegal firearm trafficking, not law-abiding citizens exercising constitutional rights. Pointing to decades of on-the-ground experience, he framed enforcement as a matter of prioritization. Limited resources should dismantle criminal networks, not surveil permit holders. The hearing then shifted to a different but equally consequential issue: nationwide injunctions. Judicial nominees were asked to define the limits of their equitable power. One by one, they agreed. District courts are not authorized to bind non-parties through sweeping injunctions. Citing recent Supreme Court precedent, the nominees affirmed that relief must be limited to the parties before the court, not expanded based on policy preferences or broader political aims. What stood out was the unanimity. Across backgrounds and appointments, every nominee echoed the same constitutional restraint. In an era of polarized courts and expansive rulings, that consensus sent a powerful signal about judicial limits and separation of powers. This hearing wasn't about sound bites, it was about boundaries. Where federal authority ends, where constitutional rights begin, and whether enforcement power and judicial power will stay within their proper lanes. If these commitments hold, they could mark a real shift in how the Second Amendment is enforced and how far courts can go in shaping national policy from a single courtroom. If you care about constitutional limits, federal overreach, and the future of American rights, make sure to like, subscribe, and share. More moments like this are coming, and you won't want to miss them.